I am not John Tomasi. He was unfortunately not able to make it today, but my name is Michael Regnier. I'm the executive director at HXA, and I'm so pleased to be joined by all of you, our members, and those watching in the live stream and on the recording. We're here today to talk about unpacking the End Woke Higher Education Act and its implications for HXA on campus. I'm joined by two of my colleagues. Our Director of Member and Campus Engagement, Martha McCoy, will be helping me ask some questions and bring out some issues in this bill, which recently passed the House of Representatives. And we'll be speaking with Joe Cohn, who's HXA's newly hired Director of Policy, one of our very expert attorneys in First Amendment law with a long history in policy and advocacy in higher education for many years with our friends at FIRE. So we're glad to have Joe on the team and be getting into this really interesting bill and what it might mean for higher education today as we chat. Let's show the next slide, please. As we go through, as with all of our HXA events, live and virtual, we ask you to do your best to follow these principles. We call them the HXA way. We'll also ask for those of you who are members of Heterodox Academy who are here with us live online in the webinar, please use the chat and especially the Q&A box to pose questions, and we'll be working your questions into the conversation today, as many of them and as best as we can. This is a dynamic conversation, and we appreciate your taking the time. We always like to invite everyone to get involved with Heterodox Academy. Subscribe to our newsletter online. Sign up for Free the Inquiry. It's our new Substack account where we're featuring a lot of different voices from our team and our academic fellows. And of course, if you're not a member, remember to sign up for membership. We're a group of academic insiders. We are from all across the political spectrum, all across the academy, different disciplines, different backgrounds, but we all care about open inquiry and viewpoint diversity and constructive disagreement. Membership is free, and we'd love to have you sign up at heterodoxacademy.org. So I guess without further ado, I'd like to talk a little bit about this bill, which has recently passed Congress, or rather passed the House, largely on a party line vote, but with a few Democrats joining the Republicans. Joe, you shared a pretty in-depth breakdown on Free the Inquiry, our Substack account, just yesterday. I think we'll share out the link here. But why don't I start by just asking, for those who have not had a chance to look at either the bill or this article that you wrote, can you hit a few of the highlights for us to help understand what it does and what it's trying to do?
Absolutely. And thank you, Michael. And thank you, everyone, for joining us in today's conversation. The bill is the Republican Party's comprehensive offering on how it would like to address some specific issues that it's concerned with in higher education. It's been, given the name the End Woke Act, unfortunately, and it's kind of inflammatory, of course, and to frame it that way. But the bill does not do any of the things that we've seen done in other bills like Florida's Stop Woke Act. We'll talk about a contrast at some point in the conversation. But for now, I want to dive into some of the important aspects of what it does. And of course, with the bill as comprehensive as this piece of legislation is, in an hour, we're not going to be able to cover all of it. So I'm going to try to tease out what I think are the things that are most pressing for Heterodox Academy. Not that the other issues in the bill aren't important to our members as well, but to our mission of supporting open inquiry, viewpoint diversity, and constructive disagreement. So with that, the bill is really a mashup of a few different other pieces of legislation that Republicans had introduced over the course of the year. And they put it into one umbrella act, the End Woke, Higher Education Act, which covers two different acts within it. So it gets confusing whenever I talk about the act, I'm going to talk about the Umbrella Act, the End Woke Act that encompasses all of it. But it also includes the Accreditation for College Excellence Act of 2024 and the Respecting the First Amendment Act as well. Now, the accreditation portion of the bill deals with trying to get accrediting agencies or setting a criteria for the Department of Education in establishing whether or not an accrediting agency can be certified and approved, that they don't hold any policy that tries to coerce or compel the institutions that it accredits to adopt particular political or ideological, litmus tests. Now, uh, the thing that is important to know about this section is that it is written broadly enough to go beyond what the GOP is particularly concerned about or sees as political litmus tests when it's coming in the DEI context to talk about any political or ideological, movement. So that's an important feature of that portion of the legislation. It also says that the Department of Education can't unilaterally add new criteria to the list that is provided by statute for what accrediting agencies need to meet in order to be certified. Right now, there are 9 existing criteria, and this bill is adding the 10th one of no political or ideological, litmus tests. So that's the general, gist. I certainly think that the GOP is thinking about this in the view of, some versions of DEI. And I know that within the conservative base, there is some disagreement about whether or not all DEI practices are politically motivated and ideological, or whether or not just some practices under that umbrella cross lines. And that's why HXA, at least in my piece here, I flagged that as an issue that we're going to continue to look at closer as the bill moves through the process to figure out whether or not it would benefit from better definitions, more precise definitions, or whether or not the definitions are really fine how they are to be understood, at least in this context of figuring out what accrediting agencies can compel institutions to do, whether it's people of ordinary intelligence can understand the terms. Don't try to force people politically in partisan ways or in ideological ways. So we're going to continue to think through that as the bill moves through the process.
Joe, let me ask, because I think this is an important nuance. Do I understand this correctly? The accreditation portion of the bill is not banning colleges and universities from teaching or researching on any particular concept. What it's doing is preventing accreditors from making their own ideological requirements of what has to happen in order to be accredited, which of course is a very important thing for any college or university that participates in federal programs. Do I have that right?
Yeah, that's correct. There's nothing in this bill, and I mean it at any point in this bill, on any of the pages of the bill, that restrict what can be taught in college classrooms or what can be researched there. So even in areas where they say, like here, accrediting agencies can't compel the institutions to take these particular stances, they're not telling them to prohibit or forbid faculty from teaching or researching however they want on these topics.
So, what are a couple of the other highlights of what's happening in this big, complicated bill?
So when you move to the section that is the Respecting the First Amendment on Campus Act, it gets broken down into several sections as well. At the top of it, it has 2 provisions that are non-binding. They're senses of Congress, which is how Congress just expresses their opinions on topics. And they start by expressing their opinion that all non-sectarian institutions of higher education should be adopting either the Chicago principles on free expression or similar commitments to free speech on college campuses. And they talk about how important free speech is to the health of higher education and why it's important to establish those principles and policies consistent with those. But that's not binding. They're not requiring any institutions to do this. They're saying Congress thinks you should. And I think that that's a good thing that they are encouraging that. Heterodox Academy for a long time has suggested that schools should be committed to the robust exchange of ideas, and we've long praised the Chicago Principles for the way it carefully addresses those issues. The next thing that it does is it goes back to this issue of political litmus tests, but not in the context of accreditation. And it criticizes, and it uses the terms condemns. They condemn it when institutions use political litmus tests to screen out applicants for admission, applicants for faculty jobs, or candidates who are already on the faculty for promotion. So it's dealing with admissions, hiring, firing, and promotion of faculty. And says there you shouldn't be using political litmus tests either, and we're going to condemn you if you do. Later in the bill, and condemn just means criticize, just means criticize. Later in the bill, there are binding sections on that particular issue of political litmus tests during in those particular contexts, uh, where Congress says public institutions of higher education may not use these sort of political litmus tests in those contexts. Uh, and again, that's another area where we are in general agreement with what uh, this bill is trying to do, and we're continuing to refine our thinking and look with a critical eye to figure out if the language is precise enough to get at the things that schools shouldn't be doing, committees shouldn't be doing in this process, while giving them the leeway to do the things that they should. And there's a list of exceptions when the bill defines political litmus tests to say that this doesn't count. Like, we're not telling you not to do this. And the most important of them, and they're all important, but the most important of the exceptions from an HXA standpoint and from an academic freedom perspective is it allows hiring and firing committees to always take into account the quality of the work product of those candidates in the fields that they're being asked to teach. If it's germane to what you're hiring them for, you always will need to be able to evaluate the quality of someone's work, or evaluate their work, period, in that space. And that sets it apart from being a quota kind of situation of thou shalt hire more people who are conservative or who are libertarian or who are or whatever the political designation here. Because if you had a department that had hired 9 people in a row who are from the same school of thought, and they intentionally wanted to add diversity of viewpoints by with this 10th hire, figuring out if someone feels differently, you're still always allowed to consider the material, and what they're going to bring in to the work there. So that's kind of a very important carve out and exception, in the list. And then, although the plain language doesn't do it, it doubles down on making it clear things like this doesn't apply to student organizations. We're just dealing with hiring, firing, promotion, and admissions. If college Republicans want to be college Republicans, they can require, their membership and leadership to be Republicans. Democrats the same, et cetera. So those are important features there. I know I'm going on a long-winding monologue, but I do want to talk about at least one more set of things that it does here, which
Please.
is free speech protections. It's under the umbrella of a section called the Respecting the First Amendment on Campus Act. And it has binding sections that apply only to public institutions, where it says that if you're going to have time, place, and manner restrictions on expression, they need to follow the same test that the Supreme Court has set. It's a case called Ward versus Rock Against Racism. It's not a campus case, but it's about free speech regulations in public spaces in general. Where it says that time, place, and manner restrictions have to be content and viewpoint neutral. They need to be narrowly tailored in furtherance of a significant interest, and they need to leave open ample alternative methods of communication. So for to unpack that legalese, essentially that means rather than create a short list of places that schools are allowed to, where schools allow students and faculty to express themselves, their rules on regulating speech need to uh, come up with the shorter list of places where they're regulating it or times. Like we want it to be quiet outside the library. Fine. You can have rules that could impact that. But a rule prohibiting distributing literature outside the library doesn't meet that goal of quiet outside the library. So that would fail under this test. And that's the test that every court case that struck down, the misleadingly labeled free speech zones have used. So that's kind of an important feature there, and it adopts Supreme Court case law. Security fees, another area where they're adopting Supreme Court case law as well.
Thank you, Joe. And I think we'll tease out a few other aspects of this bill. On the free speech section, though, there's been a little bit of pushback from, I would say, industry groups like the American Council on Education, who are arguing that these rules would essentially inhibit college leaders from effectively implementing law and order and safety on campus, and regulating protests after some of what we saw last spring. How do you read it?
So I think that the bill has a really interesting pair of ways it views enforcement. And 1 second before I get there, I want to talk about one other, kind of part of the bill that feeds directly into the enforcement mechanism, which is that it requires all institutions of higher education that want access to Title IV funds, and Title IV funds are a massive amounts of funds. You're talking about Pell Grants and Stafford loans and most forms of financial aid and federal dollars that go to some HBCUs and tribal schools. All sorts of funding is included here. But in order to access that, to be eligible, schools need to disclose to the Department of Education in a certification their policies that affect student and faculty free speech rights, freedom of association rights, and where applicable, religious freedom rights, which aren't always applicable because there are religious institutions that are allowed to limit, students and faculty rights based on religion. That's why that one is as applicable. But they need to disclose those policies. It doesn't tell schools what those policies should be or even if they have to have any. They can choose to have none. But if you have them and if you plan on enforcing rules that impact those rights, you have to disclose them before you can access Title IV funds. So, flipping to the enforcement side for a moment, the bill does two things. First, it creates a federal cause of action to sue public institutions that might have a rule, policy, or practice that violates one of the substantive rights in the bill. So, and then the other thing that it does is it says that if someone sues successfully, the institution loses that lawsuit. And they either choose not to appeal it such that the decision becomes final, or they appeal it and they lose their appeal and they lose their next appeal. Whenever it becomes kind of final, there's no more legal rungs to the fight. They have to comply with what the court orders them to do within 30 days. If the court tells them to do something after it exhausts all of that, the structure of appeal, and the school still isn't in compliance, then they lose access to Title IV funds, and they're not eligible to have them reinstated for a full calendar year. They're eligible the next time, the funds are distributed. Now, we're taking a serious, close look at that because, the competing arguments are there's so many ways you're obligated legally to comply with court orders anyway. So it's hard to feel sorry for someone who isn't in compliance with the court ordered them to do. On the other hand, the loss of Title IV funds for even a year is incredibly devastating, including to the students who rely on them to go to school, who can no longer use those grants or those loans to attend that institution. Um, so there are I think, good faith questions about whether or not that mechanism is too over the top or whether it strikes the right balance. And we're internally still discussing that at HXA, and thinking through things that we can recommend to Congress that would still have meaningful, real teeth without being quite as devastating. There might be a middle ground there. Um,
Joe, I think that's a great overview. We've also got a few questions in the Q&A, which we'll be getting to shortly. I want to bring in Martha, who's always talking to our members. Martha, what are some questions that came up for you as you were reading this that might be on folks' minds?
Well, just thinking about the ways that faculty members have, some faculty members anyway, have historically worried about the way in which free speech protections can and sometimes do get pitted against academic freedom and the academic freedom protections for faculty members in their teaching in this case. Wondered if you could talk a little bit about that. What scholars are there in the business of vetting ideas, right, based on their evidence and rigorous application of method in their discipline. And what do you say to the scholars out there who might be worried that this kind of legislation will, if it passes into law, will require a scholar to treat all opinions as if they're equal, and wouldn't really be able to do their job, which is to vet ideas and advance knowledge?
Yeah, if the bill did that, I'd be deeply concerned. And let me just say that, it's understandable for a lot of people to assume that that would be in the legislation, given, the title, the End Woke Act, and Florida's Stop Woke Act, which does precisely what you described. So completely understandable, but the bill does nothing to alter in any ways the rights in the classroom, neither enhancing them or rolling any of them back. It just flat out does not touch, uh, you know, the rights in the classroom. So faculty continue under the status quo, to be, for the most part, the rulers of their domain, deciding, what they're going to teach, how they're going to teach. If they want to do a straight lecture format where they're not taking Q&A, there are right and wrong answers on exams. None of that is changed, by the bill. Where it does weigh in is not is, again, the accrediting agency is not compelling the institutions to take particular, positions, and in the hiring and firing, not screening, people out. Now, the bill does, single out DEI as an example, of areas where they say you can't compel people to take particular positions, but quite frankly, under the First Amendment, you're not supposed to be compelling people to take any, views at public institutions anyway. So, it's underscoring and underlying a context where they think that is happening, uh, while also restating the general rule because the language itself goes broader than that context.
Thank you. Martha, did you have another question?
Well, okay, here's another one. And again, I'm just trying to anticipate what some folks might wonder. Obviously, the bill makes clear that university employees shouldn't be admitting, expelling, hiring, promoting, or firing students or faculty based on their political or ideological beliefs. Are there, and that's obviously a good protection for scholars at a university, but are there any other ways that you think scholars would technically need other academic freedom protections? I'm thinking of the freedom to conduct research without demands or fears that the faculty member is going to be fired because their research results, I don't know, say something that some wealthy donor doesn't like, and the wealthy donor is calling the university president or provost demanding they be fired. The bill doesn't talk about those things. Is that a hope that eventually there'll be more legislation that would provide greater protections for academic freedom, or maybe just talk about some of the things that doesn't protect
Sure.
the
Uh,
academic realm?
There are definitely other contexts where academic freedom are threatened that the bill, doesn't address. For example, it doesn't, for example, prevent any of the states from doing what Florida did in the Stop Woke Act and preventing what can be taught. It doesn't prevent, uh, you know, states from trying to end tenure, for example. It doesn't prevent institutions from punishing faculty for extramural, speech. It doesn't adopt, the AAUP, standards for when speech in the classroom loses its protection, which, in broad strokes is when the speech is not germane to the subject of the class, broadly construed, broadly because, for example, literature, covers the human condition so broadly that so many things can be germane, but germaneness, but then also using up a substantial amount of the classroom time, and that two-prong kind of analysis by the AAUP historically is designed to make sure that faculty still have the freedom to express views and not on such a short leash. But if you're paid to teach mathematics and you go on your soapbox for 20 minutes before each class, at some point, students have a right to be taught the subject material, and uh, and uh, and at some point the institutions have a right to insist that that occurs. North Dakota, for example, passed legislation, and I full disclosure, helped them write it, that protected faculty in that particular, context. So there are things that the legislatures, including Congress, could do. Um, whether or not it's a good idea to go down those roads often depends on what an individual legislature will look like. Sometimes the train is moving either way, so it better is good to advise them to make it look better, rather than be worse. But we're also internally discussing whether or not there are going to be opportunities to ask them to do a little bit more here, and in some instances, like in the enforcement mechanism, possibly a little bit less, uh, as well. But good question, Martha. There's definitely more that could be done. One thing I just want people to know here is this bill now goes to the Senate, where it's very unlikely to get a vote. And at the end of the year, any legislation that isn't enacted dies and has to start from the beginning of the process again. So I don't think that this is on the cusp of becoming law, but it's important for us to think through because it's a real window into how the House GOP is thinking about these higher ed issues now.
And as we know, over time, what was an early bill or even a hopeless bill for a while can suddenly become viable through the political process. So it's a good
Yep.
time to be thinking about it. We have a bunch of very good questions. A couple of them are more clarifying or technical in nature. So maybe I'll pose a couple of those to you, Joe. Martha, please feel free to continue to chime in. Our friend Maria asks, in a hypothetical, if a faculty member were compelled to promote an ideology in the classroom by their institution, but the institution justified it based on an accreditor requirement, would that faculty member have a right of action or a basis for complaint if this bill were to become law?
Okay, so let me think through that fact pattern for a second. So the accreditor requires the school to do it, and the school forces them to do it. Uh, I think that they would already have, by the way, an existing First Amendment claim on compelled speech. So there's already a way for them to litigate it. I don't know that they have a cause of action here just because of the one extra step of privity. Like the privity is a legal concept in terms of the relationship here. So the accrediting agency that that should not have been certified by the Department of Education. Um, I want to give that a little bit more thought before I'm sorry, I can't answer that one definitively here. My instinct is on first read, they probably do not have uh, a cause of action to sue here under the bill on that fact pattern, but they should absolutely be thinking through options to defend their academic freedom that are existing already.
Thank you. Our friend John Wilson asks a lovely two-part question. First, would this law ban all diversity statements at public colleges? And also, because it defines diversity, as any initiative or formulation of diversity, equity, and inclusion, would colleges, would it prevent colleges, would the bill prevent colleges from asking any applicants to support viewpoint diversity? Something we talk a lot about here. So the first part of that question, Joe, was, would this law ban all diversity statements at public colleges?
So I think no, and the reason why it doesn't is because the ban in places in the hiring, firing, and promotion context. So it's only there where there's an outright ban of don't do X, Y, or Z, or the accrediting agencies themselves of compelling, particular diversity statements. But that's kind of the tension that I was flagging early on, which is the question of, is it just particularly narrow views, of diversity that would cross into the lines of ideological, or is it all of them? Could the accrediting agency say, do something productive on diversity? That still needs to be ironed out. And when I read the bill, I've gone back and forth in terms of how I've viewed and thought it on that question over the time that I've grappled with it, because there's a tension between whether or not a person of ordinary intelligence can know what they're supposed to be doing here, and or whether or not it's so open-ended that you can never know what's allowed and what's not allowed. So that's a real, issue that we all need to think through as we're evaluating it. But whenever you're saying something is too vague, the question is, well, what definition would you use that's more precise, that still would compel that? What I hope we would agree would be a nefarious kind of act of trying to get accrediting agencies trying to force the political hands of institutions and therefore, faculty, and students. So, that's why I feel like on the accreditation side, it might be precise enough, but it might require better guardrails in the hiring and firing practice side so that, people who could get in actual trouble know what they can and can't do.
Right. And of course, in practice, sometimes the requirement is phrased as a question. Sometimes the real requirement is maybe embedded in a rubric for evaluating what people say. So it seems like there might be specific questions of interpretation that would come up if this became law. If I can give a silly example for a second, though, to the other part of John's question.
Yep.
If a university said, a public university, in order to be admitted here, please pledge fealty and undying commitment to the HXA principles, including viewpoint diversity, that would run afoul of this bill. Do I have that right?
Yeah, I mean, I think that's true, and I think that's probably correct. What I think that uh, is an important kind of concept here is that you're really talking about compelling specific viewpoints or beliefs or set of viewpoints on social, cultural, or political issues. It might benefit as John implies that a specific carve out would be helpful to say that that open inquiry, because it's at the lifeblood of an institution, is worthwhile. I mean, that kind of begs the question of the political debate about between those who think that diversity in all of it and any of its forms, and what I mean by that isn't religious versus racial versus gender, but what I mean by that is the particular different ways in which there are more partisan divides on how to approach the concept of diversity. There are some that view that some of them are inappropriate, and others who view that all of them are necessary to the institution. So, I understand the philosophical tension that exists by declaring that open inquiry is one that is necessary, but some of the views on diversity might not be necessary. I understand the philosophical conundrum there, but that's a policy question, right? At some
Yeah.
juncture.
Let me go for an easier one as we're trying to grab a few clarifying questions too. Tim asks, could you briefly explain the role that that Title IV funds play at most institutions, since those are the funds that are potentially at stake if this were to become law?
Yeah, I mean, it's a huge, set of funds. I mean, as I was saying earlier, it's, Pell Grants and Stafford loans and most forms of financial aid that students receive to go to those particular institutions. So that in itself is massive. But there are also all kinds of funds that go, to support, categories of institutions. Um, and, you know, that's uh, uh, no trifling matter. You're talking about billions of dollars here with a B, and for an individual school on an individual year, it could be tens and tens of millions of dollars that are at stake. There's been this, longstanding feeling amongst, free speech advocates in particular, that the existing remedies were a bit inadequate because, you lose a campus free speech case and the damages might be marginal, the amount of money that's awarded to the plaintiff. Um, and there are certain things where sometimes there are tensions between free speech rights and other rights like equality, and the damages were so much higher in financial terms on the equality side that schools and general counsels and risk managers were always advising them to err on that equality side of the equation. So there was, and there has been, a growing appetite to increase the pain on institutions that violate free speech rights because of how essential that is to, to the health of institutions. But striking the right balance so it isn't too draconian is a challenge. And that's what the Department of Education was grappling with. Now, in fairness to them, you lose, these same dollars if, you're found to be in violation of Title IX and don't cure, you know, or other anti-discrimination laws. So this is not necessarily, overwhelmingly groundbreaking. Just in the regulatory scheme on the other anti-discrimination laws, they've developed a lot of opportunities for a cure here. And here, the congressional statute is pretty rigid. You lose the case, you lose the appeals, and this can take place over a number of years. This is not like a fast secession. And then you don't do what the court tells you to do 30 days after they've told you to do it, then you're losing next year's funds or that year's funds. They're not building in yet additional opportunities for cure here. And they're not making it some funds versus other portions of funds. It's an all or nothing thing, which again is how Title IX approaches it as well.
Right. So thinking through, implications on campus, there's some excellent questions uh, in the chat. Um, Alex asks a question that was on my mind, which sort of has to do with that potentially blurry boundary between scholarship and ideology. He says oftentimes academic job opportunities are written to attract colleagues working in very niche areas of knowledge. It might be minority perspectives or post-colonial theory. Sometimes you see these job descriptions, I will add, that, seem to pile up all kinds of subspecialties where it almost seems as if, or maybe it really is, the case that there is one particular scholar who this is being written for anyway. He says this is especially the case in social sciences and humanities subjects, and that's one way that intellectual diversity is curtailed. I'm guessing that the bill would not be able to address this. Joe, what do you think about that?
No, I agree. It doesn't, deal with that particular issue because it provides that carve out for them to be able to consider the works of a candidate when they're germane to what they're being hired for. The problem is not, and I don't disagree with what Alex is saying here, that happens, and sometimes that happens in ways that is ideological, uh, filter and bad. But the solutions to that could be worse than the problem itself because it would also prevent, you know, bringing on people specifically to add more diversity to the perspectives that are there. Like the example I gave earlier, if a department had hired, 9 people in a row who come from the same school of thought and intentionally want to make sure they don't hire the 10th person who also agrees in lockstep. If you're not able to consider whether or not they bring something new to the table, you're, you know, stuck
Yeah.
with that possibility. So no one's come up with language yet that could solve the precise problem that Alex described, which agree is sometimes, inappropriate. But sometimes you really do want to attract the best expert on the world in, particular, field.
Right. Well, and the flip side of um, protecting uh, faculty rights is that, faculty also have a role to play. Even if Congress is not regulating something, that might be a problem that they could turn their attention to if they're involved in governance. I want to bring in a couple other quick questions. The Dave asks, why does the bill include the distinction between public and private institutions concerning free speech? Courts support free speech at public institutions, but allow private institutions to deny academic freedom and freedom of speech, even if it has been promised. So I think this might actually relate to that certification process that's built into this bill.
Yeah, that's correct, Michael. I agree with a lot of what's in, Dave, your question, but not all of it. Let me start by saying that there is an important distinction between public and private institutions because the First Amendment only applies at the public institutions. At private institutions, most courts, but not all courts, and this is the narrow disagreement here. Most courts have said that private institutions do have to abide by promises that they make. Uh, and they view that in terms of contract law. But there's these levels of the litigation of was the promise made in the first place? So you look at the any the specific contractual documents, if it's a faculty, member, and if it's a student, you usually don't have much of a contract other than the fact that you agree to matriculate, et cetera. But then they look at the policies because a lot of courts have said the policies, are, also binding as if they were contractual. But then there's this next level of who is the beneficiary of this policy? Who is the policy for? And does it actually make this requirement? Is it specific enough? So the certification process in the bill requires schools to identify these policies, but also, and I wish I discussed this up top, acknowledge upfront that the faculty and students are the intended beneficiaries of all of their policies here. So that resolves that question at all private institutions that do have any policies that regulate speech. The lines they set are the lines they set. They can't just be disregarded arbitrarily when it's inconvenient or when it's convenient to do so. Uh, and and it establishes that contractual norm. So that's why it handles it in that particular way to give private institutions the same flexibility they currently enjoy to decide whether they're in or out, to create their policies how they want, but to not let them constantly shift the ground on people once they got them to relocate their lives, whether it's to be students or faculty there.
There is a certain logic of integrity at play here, which is if you're about it, be about it, right? And don't sort of put up one face during the admissions process and then retreat to a different set of principles when the rubber hits the road. See how many metaphors I can mix there. But I mean, Joe, do you see that as sort of part of what those who voted for this bill are trying to do?
Yeah, I mean, I think so. I think that, I know for a fact that the members of the House GOP grappled for a long time about whether or not they should be asking more of private institutions or not. It's a debate that they held internally over a great number of years. And they concluded, where this bill stands, that giving them the flexibility to pick their policies is fine, so long as they actually abide by their own decisions. And I think that that's a fair, spot to land on that question. I wouldn't look across at someone who reached a different, conclusion on that question. But I think it's certainly a defensible spot to land.
Mm-hmm. All right. I've been largely not going into the partisan context of this bill, but Stephen Brent asks a fair question I want to bring up. He says the House vote on this bill fell largely along partisan lines. Can you provide a brief overview of the Democrats' arguments against the bill? I don't know if this was actually debated on the House, but Joe, you probably have a sense of why there were so many no votes from so many Democrats.
Yeah, I mean, I hate to jump into the headspace of each individual member, but I'll just disclose some just broad general, concerns I've heard over the years of different iterations of this bill, some of its precursors. I certainly think titling at the end woke Higher Education Act itself made a political statement that even if you agreed line by line with the bill and you're an elected official, it's hard, as a Democrat to uh, add your name to that branding and framing of the issues. So I think that that was a contributing factor. I think there are uh, Democrats within the caucus who think that the First Amendment principles can be defended by just relying on the First Amendment itself, that you sue under the First Amendment and no additional remedies are here. Some think that the idea that free speech is at risk at institutions of higher education is a myth. I don't agree with them on that analysis and do think that there are important ways that statutes can give easier and simpler and uh, more predictable remedies without reinventing the wheel, without changing the rules that the Supreme Court has adopted for what tests should apply in different contexts. But I think that there are Democrats who feel that way. They're also in a presidential election year, so for some of them it could just be just party politics. Um, and to be fair, I think many Republicans might behave identically if the shoe were on the other foot. So I think there are just a number of reasons here, and I think they're just the fears over what Florida did and the entanglement of getting involved in classrooms. And Florida's the only one that enacted a bill that in the end said, "Thou shalt not teach this." Um, but so many other legislators introduced bills that said that tried to get those passed. Uh, you know, so I think there's that kind of fear as well. And an election year is just not the time that they're going to be, sorting through, these things and figuring out where they're going to stand. But I think a number of these provisions could earn Democrat support. And one other factor I do want to add is that it does lack some of the things that Democrats have viewed as priorities in higher ed as well. So it's not really a bill that deals in a hybrid way with the concerns the Democrats, share as priorities. So you don't see protections um, for student journalists in the legislation, for example, that are more popular amongst Democrats. And I know it's weird to cite North Dakota as something that Democrats might be interested in, but the protections for faculty, in classroom speech aren't there, and it doesn't protect tenure, for example, things that are Democratic priorities.
Thank you. There's a whole aspect of this bill we haven't had a chance to touch on yet, and that's partly because it's outside of some of our core interests potentially at HXA. But part of this bill deals with association rights of students and student groups on campus, um, including something that I've actually heard of anecdotally. That sometimes student groups that are unpopular among the faculty might struggle to find a faculty sponsor, which can be required to unlock, university funds for their activities. Would you mind sketching out that portion? It's not all something HXA has a position on, but it might be helpful to understand.
Yeah, there are a lot of different provisions in the bill that probably fall outside of Heterodox Academy's, mission. But, those of you are members who are on campus who are thinking about the vitality of their institutions from all of the perspectives, it certainly will trigger, things that are on your minds. but student organization protections are really prominent, in the legislation. It does a number of things. The provision that you described, it deals with that fact pattern where, a student organization represents an unpopular view on campus and they can't find a faculty advisor. So the bill says in that scenario, schools must either waive the requirement of a faculty advisor or appoint someone to serve as the faculty advisor. And in the bill's only express mention of academic freedom, even though I think that the provision on the hiring and firing political litmus tests impacts academic freedom, positively. Uh, the only express mention of academic freedom is in that section where it says this doesn't mean that uh, that the faculty members can be required to do anything other than do the administrative paperwork for an organization that they disagree with, but they're recruited to serve in this function for. So it's supposed to be purely administrative, and that's designed to make sure that, that if you really load the politics of the student organization, but you're there to facilitate the fact that it exists, that your academic freedom isn't violated. And then of course other sections on student rights here include major sections about single-sex organizations, allowing them to decide their own membership requirements unless there's another source of law. So, that means that if a fraternity decides that it only wants to allow biological males in, the law would support that decision. If the same fraternity made an opposite decision, and said that we're going to allow transgendered individuals in, the law would support that too, saying it's the student organizations that get to make that decision, unless there's another source of law that says to the contrary. So, what that means is that the Supreme Court could still take up a case that decides whether or not under Title IX, transgender protections means biological sex, or whether or not it includes protections of trans individuals along the lines of the thinking in the Bostock decision. It does not upset or change that at all, but in the status quo says the student organizations, in absence of another source of law, get to make up their own minds. And then it says, and this is the one mention of academic freedom expressly, says that none of this will prevent faculty from being able to research, speak on, criticize any of those student organizations. And, other student organization protections that exist in the bill are, dealing with the controversy that we saw a few years ago at Harvard with the Harvard Finals Clubs, where it says that they can't punish students for their decisions to join single-sex organizations, and they list a number of things that would count as punishments, which denying them the ability to participate in intramural sports, for example. But the one that I think is most interesting here is they can't be denied letters of recommendation by the institution that are necessary for things like Rhodes scholarships or others where only like the dean is the only person that can provide it. Now, this was carefully crafted by Congress to say it's the institution that can't deny it. They're not going to be compelling individual faculty member, except to the extent that a faculty member might also wear an administrative hat, like a dean, a department where only the dean can recommend someone for a particular national honor. That they're not allowed to withhold that for that reason. I mean, they can withhold it for any other reason, the quality of someone's work, et cetera, their personality, whatever. But participation in a single sex organization, nope. And then it also says that student organizations get to pick their own rules for their leadership. And that's the tension between all-comers policies and these measures to give the student organizations the ability to decide who they are. And in my piece, I flag that as an issue where people have disagreed on that in terms of which one is really the anti-discrimination rule. And it depends really on whether or not you think that every organization needs to allow everyone, as diversity within organizations, or whether or not different organizations have different rules means you have a plurality and diversity of organizations. But that's the
Right.
tension.
There's always that question of at which level. Um, we've only
Can I
got about 5 minutes left. Yeah, Martha, do you want to take
Yeah.
the last couple of
Just
questions today?
just a question about the right to have a single sex student organization. And it's interesting because years ago when I was the faculty advisor to the Student Fashion Club, if anyone wants to know, they were really desperate, so they asked me to do it. But I remember the documents that really made clear to the students that they could not disallow any student who wanted to be part of the club. And this seemed like kind of legal language. So, what does it mean that, let's say, a student club forms and they want to be a men only business club and they bring Google and Amazon to campus, and those places are recruiting students for internships and possible employment positions after they graduate? Some would think that that's not fair, that the use of student fee money that goes to those events that student club or organization is funded with and using benefits one particular group, or would that not be allowed? Help us understand, like men's.
No, it would be allowed, and that's the tension. There are some who view that that as being unfair, and others who view that as being completely fair. And, for example, should Hillel be allowed to decide that its members have to be Jewish? Can they still really be Hillel if they're not? Um, you know, and uh, and the idea here is that student activity fees, by the way, are collected from all of the students, are mandatory, and the Supreme Court has said, and the bill repeats this rule, that they have to be distributed in content and viewpoint, but really viewpoint neutral way, um, which is to say that they can't provide them to college Democrats but deny them to college Republicans, or vice versa. And that's a different provision than the one that you're highlighting, but it relates here because let's say you did have a student organization that was the men's only whatever club, business club, the men's business club, and there was another organization called the Women's Business Club, and they both decided to found it and host their own programs. They'd both be allowed to do it, but the school would not be allowed to give only money to one of the two and not to the other. And that's the whole tension of diversity of or diversity within. Um, it also talks only about leadership, not really the full, requirements of who can attend events or go to events. They might not be able to have exclusive, events, but they might be able to decide who it is that their members or leadership are, their leadership roles, which is a little bit different of an issue.
Um, this is a clarifying question I should have mentioned earlier, but let's squeeze it in. When we talk about accreditors here, Joe, are we talking about only regional accrediting bodies, or are there also, for example, professional accreditors included? I think the answer is that these are accreditors of colleges and universities, but can you?
All higher ed accrediting agencies.
Mhm.
But not accrediting agencies of other like specific professions. You're not talking about the bar, for example, or the medical
Bar Association for
bar
lawyers.
association.
Yeah. Mhm.
But you are talking about accrediting agencies for all institutions, which would also include professional schools. So, law schools, for example, but not law membership.
That makes sense. Um,
Yeah.
Well, we are privileged to have new team members like Joe who are helping us dig into some of the program and policy implications of our longstanding principles. It is an ongoing conversation. We invite everyone again, if you're not a member of HXA, to join us at heterodoxacademy.org. I think we could do another hour with this group. Unfortunately, we're going to have to go. So I hope you'll join me in thanking Martha and thanking Joe and everyone who participated with us today in this pop-up conversation from
And I want
Heterodox.
to thank everyone for listening to me talk about the bill. And if you had any follow-up questions for me about it, you can email me at Cohn, Cohn, at heterodoxacademy.org. Thank you again, and thank you for the great conversation and questions.
Good afternoon, everybody.
Thank you.